for the sake of the country, that we should not grant permission.
Only it's one-sided.
We should not ignore what they are saying back here.
But it looks good.
With all respect,
I finished it up.
we don't want to move out of this courtroom.
I'm going to take it a
And then all of a sudden we are told that we have protest now in second. I'm not trying to...
Just hold on.
All that I'm saying to you...
Sorry, my lords. The utterances by the Honorable Dr. Hamino, Council, are... I'm giving you the title, sir.
No, what I'm saying, let me say what I'm...
Unfortunately, they're insightful, they are trying to preempt matters that are not before this court. We do not know and we cannot speculate that anyone is going to be happy or unhappy about it. The sword of justice cuts both ways. There are those who are going to be happy, there are those who are going to be unhappy. That is how life is, but you cannot incite by saying from here, we will have protests, we will have what? We do not know of that. And unfortunately, my lords, I ask you to kindly restrain him from taking that route.
With your kind permission, Your Honor. Sorry.
We want you to know that we have rendered ourselves in this matter. We have rendered ourselves in this matter, and we are not going to open this matter for a further court proceeding. There are two applications before the court, one by Dadlo Chieng and one by Ndegwa. After Dr. Kamuna has spoken, we'll allow two people to respond, and then we'll make a ruling.
Thank you.
I know that was also you indicated we have two people, and I was prepared kindly to make an application.
Continue, Dr. Kamuna.
You know, I'm actually it's only one sentence. When you read the book, I have referred to authorities in America. The judges have made a finding along this line. Yes, this is the people. So and so is people. But we shall not go ahead and do that. We shall be him. So that's all I'm saying to you. You have come up with a very familiar a ruling full of students, and particularly Madam Lord President has come up with something that I had not thought of very much at all. But all I'm saying to you that you agree, but you still have the discretion to say that look, we have still our findings, but still we are going ahead to deal conservative orders for so many days or so many weeks. So you still have that discretion.
Only one response.
Yep, my lord, if I may respond, my lord.
My lord, kindly. With the permission.
My lord, you made a ruling.
Okay. Okay. Let me hear two people from this side, and two people.
And two.
I'm 42. Allow me to say something.
You're one person.
Allow me to say something.
Dr. Kamilwa, please say what you want to say and be mindful of time, please.
Yeah, I want to take my time. There is Eric Ogola. There is Andrew Urema. There is Joseph Frida Ugandi. I've listened to what you have said very carefully. And from my point of view, one of the interested in developing the goodness of the country. You have done so. You have developed. But there is one thing I would like to point out to you very first. That we are operating in very dangerous waters. With the form current. And this is an area where we have to call for wisdom. We have to call for deeper understanding of human nature and for deeper understanding of the society which we live in Kenya. And what I'm saying to you is reflected in my broad reading of the authorities in cases in the United States of America. Your Honor, if I may say so with respect, perhaps more than anything else, when I was engaged to get involved in this case, I ordered for a book from India straight about the legal report on impeachment. And I've taken the trouble to read them day and night. And one thing that has emerged from all these authorities when I was reading them very carefully is that the court in the United States have continued to think very carefully how will this judgment be received by the people, by the consumers. How will it be received? Is it a judgment that will continue to promote stability in the country? Is it a judgment that will continue to promote the rule of law? Is it a judgment or ruling will continue to promote stability in the country? And it's here that I'm inviting you very respectfully that you consider the able remarks of my learned friend, Mr.
How would Kenyans receive the decision? I'm not so sure whether this is what these applications should be based on, because whichever way, there will be parties that will be aggrieved by the decision. There are many others that will be satisfied. Do not be misled that there would be protests, just the way I also cannot mislead you by saying there will be jubilation and celebration everywhere. The position remains, the court has rendered itself in a decision, the court is functus, and therefore we have now to move on. Any party aggrieved knows what to do, which is either to appeal, apply for a review, variation, or whatever it is they have to apply for. If the processes that will take place after this would be contra the Constitution, every party knows what to do, and this court is still seized of the matter, and they will be coming over here for a pronunciation on what the constitutional rights are. Therefore, we should actually not be taking the route that the decision may be popular or unpopular. It's a decision of the court, and it cannot be challenged along those lines.
Thank you.
My Lord, honoring the court and my colleagues' time, this is my rejoinder in exactly 2 minutes. My Lord, Rule 32.2 of the Mutunga Rules allows us to make this application informally as we make it. Rule 32.2 of the Mutunga Rules allows us to make a Magu paper application as we do. It says the application can be made informally immediately after delivery of the judgment. Rule 32.2 Mutunga Rules. My Lord, the President, the Attorney General, when on the other side, has many times sought a Magu paper injunction. In the Finance Act litigation, where my friend Mr. Somane was present, Justice Majanja presiding, this court, in this room, issued a Magu paper injunction. My Lord, on the last point, my learned friend Mr. Ojenda sounds familiar with the Magu paper case. It's a court of appeal decision. I saw the first one, Batch versus Rent Tribunal, is one of the most cited cases on the question of stay. And in that case, the Court of Appeal said, my Lord, allow me to read, and then I'll sit down. There is no inconsistency in granting such an injunction, a Magu paper injunction, after dismissing the motion. The purpose of the order is to prevent the Court of Appeal's decision from being rendered nugatory. Should that court reverse the High Court's decision? Respondents concede that you could be wrong. There's human infallibility. The purpose of the request we make is to respect that issue. What if you're wrong? And you allow the wrong person to come into the high office you've just established. My Lord, allow the request for 7 days. Thank you so much, my Lord. And my Lord, may I just clarify that our application is distinct. We do not seek stay, we seek an injunction. Thank you.
And I'm interested in the event, my Lord, it's allowed. Can we also move you again to remove it?
Orally,
No, my Lord, I think in the view of Article 50, they also have a right to make that application. Your Lordship, allow me to draw your attention to Article 149 clause 1. That London is not burning, and that a vacancy is contemplated, and actually a vacancy of 74 days, within which due process ought to be initiated to ensure that a rightful person, fully qualified, fully known in law, fully appreciated by the law, takes over office. Therefore, this vacancy is a constitutional vacancy. Further to that, Your Lordship, permit me to address you that this is a new application and this application has not been determined. Further, allow me to indicate that I listened pensively to the 3 thematic issues that were raised by the court, and this is not one of them that was raised and resolved by the court. Finally, Your Lordship, we all have a duty to uphold the law and to defend the Constitution. On the 16th of October 1953, Fidel Castro had this to say in his defense, that history will absolve me. History will absolve the petitioners. That you have brought to your attention that you have the duty to protect the Constitution, that a person qualified should take over. I'll wait for the ruling. Finally, Mr. Somane has not addressed you on the qualification and the ability of a person to meet those qualifications under Article 99 and Article 97. He has not even told you that they are not applicable. If the court wants to say they are not applicable, history will absolve me. If the court wants to say that it has no power to defend the Constitution, history will absolve me. If the court wants to pave way and mutilate this Constitution, history will absolve me. If the court wants to midwife an injustice, history will absolve me. I am most obliged.